The notice was stapled to the fence post at the entrance of the road. Harlan Briggs saw it when he came back from the south field just after noon. White paper, official state seal at the top, the kind of document that arrives without a phone call and without warning and expects to be obeyed without question. He pulled it off the post and read it standing in the dirt. The State Department of Transportation had determined that the half-mile gravel road running from the county highway to Harlan's property was an unregistered access route with no verifiable private ownership record. Under current state infrastructure review, unregistered access routes adjacent to county-maintained roads were subject to reclassification as public easements or, where applicable, incorporation into the county road network. Harlan had 30 days to provide documentation of private ownership or the road would be reclassified. He read it twice. Then he folded it carefully and put it in his shirt pocket. He was 74 years old. He had been maintaining that road since he was 23, grading it every spring after the thaw, filling the low spots every fall before the freeze, replacing the culvert twice with his own equipment at his own expense. 61 years of work on a half-mile of gravel that connected his farm to everything else, and now the state was telling him it might not be his. Harlan looked at the fence post where the notice had been stapled. Then he got back in his truck and drove to the farmhouse. He knew exactly where to look. Harlan Briggs had inherited the farm from his father, Gene Briggs, in 1971. Gene had bought the property in 1952, 210 acres in central Missouri, good bottom land along the creek, higher ground to the north that held up well in wet years. The road had existed when Gene bought it, a rough track running from the county highway through the tree line to the farmyard. Gene had graded it himself the first summer and kept it up every year after that. When Harlan took over in 1971, he kept the same system: spring grading, fall patching, culvert maintenance when the drainage required it. He had never thought of the road as anything other than his. It crossed his property. It served only his farm. He had maintained it for 61 years, without assistance from the county or the state or anyone else. What he had not thought about in a long time was the paper. His father had been a careful man, not educated in any formal way, but careful in the way that mattered, which was to say he did not sign things he had not read, and he did not read things he did not keep. When Gene Briggs had arranged the original road agreement in 1952, formalizing the private access route as part of the property purchase, he had filed the documentation with the county and kept a copy in the metal strongbox under the bed in the back bedroom. That strongbox had passed to Harlan along with the farm. Harlan had not opened it in 11 years. He opened it now. The strongbox was exactly where it had always been. Harlan carried it to the kitchen table and set it down. The latch was stiff from years of sitting undisturbed. He worked it open with a flathead screwdriver and lifted the lid. Inside were the documents his father had kept: the original 1952 deed, the property survey from the same year, tax receipts going back to the beginning, correspondence with the county about the farm boundaries, and near the bottom, in a manila envelope labeled in his father's handwriting, Road Agreement, 1952, a folded document that Harlan had not looked at since the year Gene died. He unfolded it carefully at the kitchen table. It was a private road maintenance and ownership agreement executed between Gene Briggs and Callaway County in August of 1952. The document established the half-mile gravel road as a private access route under sole ownership of the Briggs family, with full maintenance responsibility assigned to the property owner and no county obligation for upkeep or repair. The agreement was signed by Gene Briggs, countersigned by the Callaway County Road Commissioner at the time, filed with the county clerk's office on August 14, 1952, stamped, received, and recorded. Harlan read it twice. Then he looked at the state notice on the table beside it: unregistered access route with no verifiable private ownership record. He sat with that for a moment. The road had been registered in 1952, filed with the county, stamped and recorded. The agreement had been sitting in this strongbox for 72 years. The state system simply did not have it. Harlan picked up his phone and called his daughter, Carol, in Jefferson City. Carol was 46, worked as an administrator for a county planning office, and understood how state infrastructure systems worked better than most people who had never had a reason to learn. He read her the notice. Then he read her the 1952 agreement. She was quiet for a moment. Then she said, "Dad, do you understand what this means?" Harlan said he thought he did. Carol said, Their system shows no record because county records from before 1970 were never fully digitized in most Missouri counties. The original filing exists, but it is in paper archives that the State Infrastructure Review did not access. She paused. They sent you that notice based on incomplete data. Harlan looked at the agreement on the table. He said, "So the road has always been mine." Carol said, "It has always been yours. It was registered the year Grandpa bought the farm." She paused again. "Dad, you need a lawyer. Not because this is complicated, but because the state needs to hear this from someone they are required to listen to." Harlan said he knew who to call. The lawyer's name was Clifford Marsh, 62 years old. Boonville, Missouri, 34 years handling property and municipal law across central Missouri, a man who had spent 3 decades in courtrooms and county offices and had developed the particular patience of someone who understood that government agencies moved slowly, but moved, and that the key was knowing exactly which document to put in front of which person. Harlan drove to his office the following morning. He brought the strongbox. Clifford read the 1952 agreement without speaking. Then he read the state notice. Then he read the agreement again. When he set it down, he looked at Harlan over the top of his reading glasses. This agreement was filed with Callaway County in August of 1952. Harlan said yes. Clifford said, and it has never been challenged, amended, or voided in 72 years. Harlan said, not once. Clifford picked up his pen. The state's infrastructure review operates from a digitized database of road records. Records from before 1970 in most rural Missouri counties were not included in that database when it was built. He wrote something on his notepad, which means the review system identified your road as unregistered because the registration predates the system's records, not because it doesn't exist. Harlan said, "That's what my daughter said." Clifford said, "Your daughter is correct." He set the pen down. "Mr. Briggs, this is not a complicated legal matter. The documentation exists. It is valid. It predates the state's claim by 72 years. What we need to do is put it in front of the right people in the right way so that the state's position can be formally corrected before their 30-day deadline." Harlan said, "Can you do that?" Clifford said, "I can do that in about a week." Then he picked up his pen again and started writing. Clifford filed the response on a Thursday. Not in court, not yet. First, he filed directly with the Missouri Department of Transportation's district office, with a formal letter attached to certified copies of the 1952 agreement, the original county filing stamp, the property survey, and a chain of title documents showing uninterrupted Briggs family ownership of the property from 1952 to present. The letter was 4 pages. It explained the situation without drama and without accusation. The road had been registered as a private access route in August of 1952. The registration had been filed with Callaway County and stamped received. The state's infrastructure review had not accessed pre-1970 paper archives and had therefore identified an existing registration as absent. The notice issued to Harlan Briggs was based on incomplete data and should be withdrawn. Clifford also filed a formal request with the Callaway County Archives Office to retrieve and certify the original 1952 filing, creating an official county certified copy of the document that would satisfy any subsequent state records requirement. The county archives office found the original filing in 2 days. It was exactly where it was supposed to be. Paper records, pre-1970 files, the original road agreement, county stamp still legible, filed in the correct folder under the correct year, sitting in the county archives for 72 years waiting for someone to need it. The certified copy arrived at Clifford's office on a Friday morning. He sent it to the state district office the same afternoon. The state's response came 12 days after the original filing. A letter from the district infrastructure coordinator, formal and measured in tone, acknowledging that a review of the submitted documentation confirmed the existence of a valid private road ownership agreement predating the current infrastructure review. The notice issued to Harlan Briggs was formally withdrawn. The road was reclassified in the state system as a registered private access route under Briggs family ownership. No further action was required. Clifford called Harlan the morning the letter arrived. He read him the key paragraph. Harlan listened without speaking. When Clifford finished, Harlan said, "That's it?" Clifford said, "That's it. The notice is withdrawn. The road is yours. It was always yours." Harlan said, "How much do I owe you?" Clifford told him. Harlan said he would bring a check by the office. Then he hung up and sat at the kitchen table for a moment. The strongbox went back under the bed in the back bedroom. Harlan put it there himself, the same place his father had kept it for the 20 years between buying the farm and dying, the same place Harlan had kept it for the 53 years since. He closed the lid and made sure the latch was seated properly. Then he went outside. It was a November morning, cold and clear, the kind of morning that central Missouri produces in the weeks after the harvest, when the fields are empty and the light comes in low and flat from the south. Harlan walked to the fence post at the entrance of the road. The state notice was long gone. The staple hole in the post was still there, small and dark against the weathered wood. He looked at it for a moment. Then he turned and walked the road, all half-mile of it, the same gravel he had been grading every spring since he was 23 years old, the same low spot near the creek crossing that collected water in wet years and required filling every fall, the same culvert he had replaced twice with his own equipment because the county had no obligation to do it and he had never asked them to. 61 years of maintenance, his father's 20 years before that, 81 years of the same family keeping the same half-mile of road in passable condition for no reason other than that it was theirs and they were responsible for it. The state had sent a notice based on a database that stopped at 1970. His father had filed the agreement in 1952, 18 years before the database began. Harlan reached the county highway at the end of the road and stood there for a moment, looking back the way he had come. The gravel ran straight through the tree line to the farmyard where his truck was parked in front of the house his father had built in 1954. Nothing about it looked different than it had looked yesterday. Nothing about it had changed. It was his road. It had always been his road. And in a strongbox under a bed in the back bedroom of that farmhouse, a piece of paper filed with Callaway County in August of 1952 had been waiting for 72 years to prove it. Some things do not need to be used to be valuable. Some documents sit in strongboxes for decades without being opened and do their work simply by existing, simply by being there when the day comes that someone needs to know the truth of a thing. Gene Briggs had filed that agreement in 1952 and never once mentioned it to his son, not because he thought it unimportant, because he trusted that it would be there when it mattered. It was there. It mattered. If this story meant something to you, subscribe. Hit the bell so you never miss what comes next. We will see you tomorrow.